So on July 15th, just 2 days ago, Senator Adam Schiff from California questioned acting AG Todd Blanche on something confirmation hearings almost never reach. It wasn't about, like, policy, not about procedure, but about identity. He asked him directly, "What happened to you?" And I need you to understand basically exactly who this guy was before we get into what he's done. We're talking about like 8 years as a federal prosecutor at one of the most demanding courthouses in the country. Former colleagues called him brilliant. His reputation crossed party lines. And yet, testifying before the Senate Judiciary Committee, seeking confirmation as the nation's top law enforcement officer, a job he's actually been doing since April of this year, he had to answer for a documented record that a federal judge had spent days dismantling just before that hearing. Because that exchange is part of a much bigger story. Court rulings, government filings, and a letter that hundreds of his own former colleagues signed just 9 days ago. All right, let's watch this.
Administrations, the letter states that Mr. Blanche has, quote, gone a long way to restoring faith in the rule of law and has been especially encouraging to pro-life cause, for which so long has been relegated to a second-class status, end of quote, without objection. That'll be entered in the record. Senator Schiff.
Thank you, Mr. Chairman. Mr. Blanche, you represented the president in at least three criminal cases, the hush money payment case in New York, the January 6th case, and the Mar-a-Lago classified documents case. You said when you appeared last before this committee you would consult with ethics lawyers about that apparent conflict of interest in handling any case involving the president, having been his personal counsel. Did you consult with Joseph Terrell, a senior ethics lawyer at the department?
I believe I met with Mr. Terrell, yes.
Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior representation of the president?
Yes.
So in those three matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself?
I'm recused, correct. Well, by the way, the cases are not ongoing, Senator, but to the extent there's any work around those cases, yes, I'm recused.
So you said to CPAC a couple months ago, the other things that are happening, there is not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. So you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client? There's no conflict there? Is that
no, there is. I wasn't involved.
So
that would be a conflict.
At CPAC, you're taking credit for the firing of these Department of Justice lawyers, but you're not willing to take responsibility before this committee. Is that the case?
No.
Okay.
There's a statement I gave at CPAC.
You were bragging about this at CPAC, the firing of these prosecutors, the firing of the FBI agents, the getting rid of everyone who investigated your client. You were proud of that, speaking for the Department of Justice, but you don't think that's a conflict of interest. You moved to vacate, I don't think you're going to deny involvement in this, you moved to vacate the convictions of 12 Proud Boys and Oath Keepers, which erased their convictions, restored their gun rights. These people were convicted in the January 6th investigation, which also involved the president, who you represented. You were involved in dismissing those cases, were you not?
I'm the acting attorney general, so yes, my department moved to dismiss. I was not involved.
So you didn't recuse yourself from that matter. You were willing?
There's no reason to. From the Proud Boys matter?
Yes, it was.
Lawyer, you know the rules. There are rules that say when I have to be recused, and that's not one of them.
And there are rules, and when you're told to recuse yourself from investigations that you handle for the president, you're supposed to recuse yourself.
No, when I represented the president.
You've also said, you've also refused to release Volume 2 of the Special Counsel's report. That was an investigation into the Mar-a-Lago documents case. How is that not an abundant conflict of interest? Refusing to release to the public an investigative report of an investigation into your client.
I am not a judge. A federal judge.
No. The department's position under you, Mr. Blanche, was do not release the report.
So that position,
If you went into court asking them to release it, it would be released by now. So how is that not a patent conflict of interest?
what you're saying happens to not be true. I did not do that. What you're talking about happened before
So
I became the
you
Deputy Attorney
support the
General.
release of Volume 2?
No, I don't, but I'm recused and had nothing to do with that case. Like, you can't accuse me of violating my ethical rules and then lie about what I did.
So you had nothing to do with the decision to prohibit the release of the report? You had nothing to do with the department's
wasn't in court.
position?
I
No, I'm
wasn't
not
the
asking whether
deputy-
you were in court.
I was-
I'm asking you whether anyone sought your opinion or used your guidance in refusing to release Volume 2.
When
You're
that
saying you had nothing to do with
when
that decision?
litigation was ongoing, I was a private citizen, still representing the President of the United States. It was before March. Since March, to the extent there's been anything in front of that judge,
Mr.
I
Blanche,
haven't been part of
I
it.
asked you in your last confirmation hearing whether you would release the report, and your answer was no. Your answer was not, I will recuse myself. Your answer was, no, I will not release the report. That was your testimony last before this committee. You subsequently were advised by ethics lawyers not to be involved in these matters, but it appears you were involved in these matters. Let me ask you about another matter.
I
you
wasn't
were-
involved.
Well,
You can't
let me-
say it
let me-
appears I was
okay,
involved
all right,
when I
well,
said I
let me-
wasn't.
Let me ask you about another one you have your
I mean,
name on.
geez, the truth has to matter at some
yeah,
point.
it does matter. We just don't hear much of it from you. But let me ask you about another matter you have your name on. I don't think you can deny responsibility here, and that is the IRS settlement agreement. So
Yes.
you put your name on this. That absolves the president of tax liabilities in the past. The president was convicted in the case you represented him in of falsifying business records in part for tax purposes. Does this settlement not absolve the president of any liability for tax crimes associated with what he's already been convicted of?
That's not what he was convicted of. Not having to do with
Well,
for tax
I'm happy to
purposes.
read the statement of facts. The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. So you know,
The
Mr.
participant
Blanche,
there was not the
you-
president. It
you-
was somebody else.
Well, if the president is conspiring with others to falsify business records to help them cheat on taxes, he is also exposed to liability. You know that as well as I do.
He can't be audited for that.
And of course he can be. Of course he can be. And he can be prosecuted for it. But the agreement you signed on behalf of your former client, on behalf of your current client, in a staggering example of self-dealing prohibits that. Let me ask you this. Does this tax agreement, this addendum you signed, also hold him harmless from any audit or tax liability with respect to the billions in crypto money he made in his first year as president?
It's not forward-looking. So to the extent there are taxes filed by the president or his sons or the Trump organization after the date of that agreement, there's no protection.
Well, but before that agreement, so any
So he
taxes...
hasn't filed taxes
so
yet
any-
for money he made last year, right? So
Yes.
no.
So if he...
So no protection.
If he filed tax returns this year for money he earned last year, that his sons earned, that his World Liberty Financial, all those people earned and defrauded taxpayers on it, he faces no liability under this
No
agreement you
evidence. There's
signed.
no evidence taxpayers were defrauded, and he
But
is not
there's
protected. He is
evidence in
not
this
protected.
agreement
He's
that
not
you've
protected.
absolved him of any liability over.
No, I
it.
just said he's not absolved. So the question
So this
was,
agreement doesn't apply to a tax return filed last year
To
or
tax
filed this
returns-
year?
to tax returns filed after the date of the agreement? No,
No,
it does not
before the
apply.
agreement. A tax return filed in this calendar year before this agreement.
Before the agreement, it applies, not
Yes,
after.
okay, so for a tax return filed this year for last year, for the billions he made, there's no tax liability even if he cheats on his taxes or his kids do or his business do. He is absolved of that further potential liability.
No.
Well, it's in the plain language of your agreement. Did you write this language,
You
by the
have to
way?
use the facts, though,
Did
that
you-
he hasn't
did
filed
you-
taxes yet. So when he files taxes, there's no protection based upon this agreement.
Did you write this language?
Did I type it up myself?
Did you write this language?
No.
Well, you put your name to it.
I did.
So who wrote this?
I don't know the person that actually typed it. I don't know who it is on
Was
someone
it,
within
was
the
it
Department
one
of
of the
Justice.
president's lawyers or was it someone from the Justice Department or IRS?
This document would have been
Yes.
somebody within the Department of Justice.
Well, you have no idea who that is.
I don't know the name of the person that typed it up.
And did you debate with them the statute of limitations, which clearly would preclude the president's claim, this $10 billion lawsuit?
We had extensive discussions internally about the underlying litigation.
And did you reject the statute of limitations defense?
I'm not a judge. I don't reject
But
things.
you signed an agreement for the
There
U.S.
was discussion around
you signed an
litigation.
agreement for the U.S. basically indicating that the Justice Department's position that the statute of limitations applies doesn't matter.
I did. That's not what I said. I didn't say that anywhere.
Who rejected the 25 defenses the IRS had to this sham lawsuit? Who rejected them? Who said that these defenses we're not going to accept, we're just going to go with the president's agreement in the slush fund in this immunity?
There was a lot of discussion internally.
But you made the decision.
What's the decision? What do you mean?
You made the decision to not defend the IRS and the Justice Department. You made the decision instead to sign this slush fund agreement.
We made the
with
decision to settle the case, correct?
Yeah. And in doing that, you basically decided that you were going to be the lawyer for the president and the lawyer for the IRS and the Justice Department. As the court found in this case, there was no adversarial relationship.
Yes,
the court found it was a sham. It was a collusive relationship. And what I don't understand, Todd Blanche, what happened to the Todd Blanche who was a prosecutor in the Southern District of New York? What happened to the prosecutor people had respect for? What happened to the prosecutor who once respected the rule of law? What happened to the prosecutor who said that there wouldn't be a whiff of political partisanship and then prosecutes the president's enemies over Seychelles cases, over making a video stating the plain law and Constitution? What happened to the Todd Blanche of the Southern District of New York that could convert him into you, someone willing to say the president has both the right and the duty to prosecute his political enemies? I cannot imagine the Todd Blanche of the old days would have ever done that. What happened to you, Todd Blanche? I'll tell you this. I think Robert Caro had it right when he said that power doesn't corrupt as much as it reveals. I suspect it has just revealed who you are. And who you are is someone willing to sacrifice everything you once believed in for that title, for that position of Attorney General. And it is a sad story that we have seen from Trump appointee after appointee after appointee. We have seen people compromise themselves little by little and then a lot by a lot until they're sitting before this committee and trying to justify the unjustifiable. I yield back.
May I just briefly respond, Chairman?
Yes, you may.
Very briefly. So you asked me what happened to Todd Blanche. I am still here. I am the same exact person I was when I was a federal prosecutor in the SDNY, which is do the right thing and do everything you can to keep communities safe. So when I was a line prosecutor, when I was a supervisor, when I was the head of a division, my motivation and my goal was the same thing with the people who worked with me and worked for me, which is do the right thing, enforce the laws, and put bad guys in jail. And so you spend time talking about, I did not interrupt you. I did not interrupt you. A little courtesy would be appropriate. So when you ask me what has changed, okay, and you talk about a single document that I signed, okay, and somebody had to sign that document when the president sued, okay, so I tried to do the right thing. What I do every single day, and what the prosecutors in this country do every single day, and the nearly 100,000 indictments and informations that have been filed since January 20th, is exactly what everybody in this building should want the Department of Justice to do, which is to make our communities safer, enforce the laws, both civilly and criminally, and always do the right thing with integrity, which is exactly what I'm doing. So I am the same Todd Blanche I was when I was a federal prosecutor in the SDNY.
Before I call on the last senator to ask questions, I'd like to enter into record a letter supporting.
Okay, so let's talk about who this guy actually was, because it makes what he's done so much more damning. Get this. He attended Brooklyn Law School at night, literally like at night, while working as a paralegal during the day, putting himself through law school while supporting a young family. By 2006, he's joined the Southern District of New York as a line prosecutor. By 2014, he's co-chief of the Violent Crimes Unit, overseeing about 24 prosecutors handling murders, kidnappings, rapes. But then, two of his former SDNY colleagues, Mimi Rocah and Perry Carbone, people who once called him a close friend, published an op-ed this morning characterizing what he's done as painful. They said his prosecutorial background gives him basically absolutely no excuse for what he's overseen because he knows exactly how these guardrails work and exactly why they exist. So that's who we're dealing with. Now, let me explain the IRS settlement, because this is like the crazy piece of this story, and I want to be very, very clear about what actually happened here. Back in May of this year, he signed a settlement agreement resolving a $10 billion lawsuit that the president had filed against the IRS. In January, yes, Trump sued his own IRS, alleging a government contractor leaked his tax returns and dismissed it voluntarily. The settlement initially created a fund of $1.776 billion drawn directly from the United States Treasury, meant to compensate anyone claiming the government had, unfairly targeted them for prosecution. Of course, he abandoned that fund after fierce bipartisan backlash. But guys, here's the part that is still in effect. Right now, today, he signed a separate addendum himself on May 19th, permanently barring the IRS from auditing, examining, or pursuing any legal action against Donald Trump, his two oldest sons, or any Trump Organization entity for any past tax returns forever. And your tax dollars paid his salary while he did it. Citizens for Responsibility and Ethics in Washington, the nation's leading government watchdog group, literally called the arrangement the most brazen act of self-dealing in the history of the presidency. But it gets worse. Now, just 2 days before his confirmation hearing, U.S. District Judge Kathleen Williams released a 56-page opinion dismantling that deal from the ground up. Just think about that timing. She found the lawsuit served basically absolutely no legitimate legal purpose, that Trump and the Justice Department he controls were never genuine adversaries in the case. She determined the settlement flat out violated federal law, describing it as wholly incompatible with the department's duty to protect the public interest. She actually directed her ruling to be sent to both the Acting Attorney General's State Bar Association and that of Associate Attorney General Stanley Woodward, where ethics complaints were already pending, citing her serious concerns about their conduct. She separately referred Trump's own personal attorney in the case to the Florida Bar for potential discipline, and she found that the tax amnesty order the Acting Attorney General had signed directly contravenes a federal statute specifically barring executive officials from influencing tax audits, meaning, a sitting federal judge concluded in a published ruling 48 hours before his confirmation hearing that the acting attorney general may have violated the Constitution. I need you to literally think about that for a second. And here is basically exactly why that immunity order actually matters. The president's annual financial disclosure, released publicly just 2 weeks ago by the U.S. Office of Government Ethics, showed he earned more than $1.4 billion in cryptocurrency income during 2025, his first full year back in office. More than $500 million of that came directly from World Liberty Financial, a crypto company his sons co-founded during the 2024 campaign. Another $635 million from sales of his branded meme coins, meaning his total disclosed income for the year exceeded $2.2 billion, a financial picture completely without modern presidential precedent. That tax amnesty covers all returns filed before the addendum's cutoff in late May 2026. And while her ruling found it may be unconstitutional, it remains in effect. But wait, because now, there's a report you've never been allowed to read. And I really want you to understand why. Former special counsel Jack Smith produced 2 volumes of findings. The first, covering January 6th, became public in early 2025. The second, covering the classified documents case at Mar-a-Lago, contains the basis for 40 felony counts. Allegations that the president knowingly retained hundreds of classified records at his Florida club, defied subpoenas, obstructed investigators, and lied about still having them. But Aileen Cannon, a federal judge, permanently sealed it in February of this year. And then, just 2 days ago, in that same 48-hour window as the judge's ruling, the Justice Department filed legal briefs in the 11th Circuit actively supporting that blockage, filing the exact same arguments as Trump's private legal team. So Americans still don't have the right to read the findings of a, completed federal investigation into the person the acting attorney general used to personally represent. Let me say that again so it sinks in. The government's top lawyer is helping block the release of an investigation into his former client. And now, consider the convictions. Back in April, the Justice Department asked federal appeals judges to permanently erase the seditious conspiracy convictions of 12 leaders of the Proud Boys and Oath Keepers, people whom juries had already convicted at full trials for organizing the assault on the Capitol. And the judge who ultimately granted those erasures, Timothy Kelly, literally like a judge the president had nominated, he explicitly stated in his ruling that his decision didn't mean he agreed with it. He said he had basically absolutely no practical choice. The executive branch had refused to continue prosecuting cases it had already won. So the convictions vanished, and so did the gun restrictions that came with them. And if that wasn't enough, well, then there's this. Since the mass pardons of January 2025, multiple recipients of the president's January 6th pardons faced prosecution for entirely different and far more serious offenses. NBC News reported that Daniel Tachi received a 4-year federal prison sentence for possessing what prosecutors described as an enormous child pornography collection. Andrew Paul Johnson received a life sentence for child molestation. David Daniel, who admitted to assaulting law enforcement during the Capitol attack, later agreed to plead guilty in a separate child exploitation case involving multiple victims. Because, look, a pardon clears a record and restores legal standing, but it doesn't screen for what a person does next, or prevent prosecutors from discovering who they already were. But then, here's what he said under oath Wednesday. While answering a question about his relationship with the president, he literally said, on the record, under oath, I'm his lawyer. He caught himself. Corrected it was his lawyer. But guys, that slip connects to something that is actually documented. At his Deputy Attorney General confirmation in early 2025, he testified under oath, I have an attorney-client relationship with President Trump. Those were his basically exact words. In a prior sworn proceeding, while seeking a job that put him in charge of a department actively handling cases that directly touched that client's interests. So the man who acknowledged an ongoing attorney-client relationship with the president in his first confirmation hearing is now asking the Senate to confirm him in his second. I know, shocking, just completely mask off. And you have to consider what the department he runs has done to those it's labeled enemies. In April, it secured a second federal indictment against former FBI Director James Comey, specifically for posting a photograph on social media. The photograph depicted seashells arranged to spell, 8647. And prosecutors claimed that arrangement constituted a criminal threat against the president's life. Jimmy Gurley, a Notre Dame law professor and former federal prosecutor, told CNBC the indictment was an embarrassment to the American criminal justice system because restaurant and kitchen workers across the country immediately pointed out that 86 is just standard service industry shorthand for removing something from a menu, a phrase anyone who's ever worked a line shift knows by instinct. Comey denied the charges and described the case as completely politically motivated. And then there's the letter, and guys, this one's incredibly important. Just over a week ago, more than 1,200 former Justice Department employees signed a 59-page letter organized by the alumni group Justice Connection, urging the Senate to reject his nomination. And these aren't partisans. The signatories served under both Republican and Democratic administrations across 14 presidential terms. Their central argument set aside the specific legal controversies and focused strictly on what's happened to the institution itself. Because under his watch, more than 16,000 DOJ employees have left. A quarter of the department's attorneys have departed. Workers faced firing for declining politically targeted prosecutions, for refusing to make false representations in court, for processing immigration cases with due process protections. The letter's conclusion was basically clear. The culture of fear Blanche has instilled within DOJ's workforce must end. And here is the thing. Well, even within the Republican caucus, specific documented concerns have surfaced. Senator Thom Tillis, who's heading into retirement, told colleagues he expected to see the department operating with genuine independence. Senator John Cornyn, also departing, said publicly that the nominee would be serving the nation as its attorney general. And both said that before the confirmation hearing made the full record literally impossible to ignore. And remember, confirmation now requires every single Republican vote following the unexpected death this past weekend of Senator Lindsey Graham, who had been widely expected to support the nomination. His vote is gone, which means one defection kills the nomination before it even reaches the Senate floor. Now, Adam Schiff closed his questions with a quote from Robert Caro, the Pulitzer Prize-winning biographer of Lyndon Johnson and the most celebrated student of American institutional power in the last century. And here's what Caro argues, and guys, this is the part that I think cuts the deepest. The old maxim about power corrupting people, it actually gets the mechanism wrong. What he found, across decades of studying men who held extraordinary authority, is that power strips away the concealment people maintain while climbing toward it. When someone's still ascending, they have, reasons to appear a certain way, but once they hold the thing they've been reaching for, all those reasons disappear. In his formulation, power doesn't corrupt as much as it reveals. And that gap between being transformed by power and being exposed by it is the exact difference between someone who lost their way and someone who arrived exactly where they were always heading. And I want to bring this down to you specifically, because this isn't just abstract. The Internal Revenue Service has a specific job, auditing high earners, investigating tax fraud, applying the tax code without preference for who holds power. But that agency now operates under a permanent Attorney General order, an addendum he signed himself, instructing it to stand down from examining the current president's family's past finances. The Justice Department has a specific job, prosecuting serious crimes impartially, completely without regard to who committed them. And yet, federal judges in multiple proceedings have recently found the department's filings incompatible with that mission. The person seeking permanent confirmation at the head of those institutions wants the Senate's approval to continue making the exact choices that generated those rulings. Because basically, power reveals. And the Senate's confirmation vote is exactly where the country decides what to do with what it shows. Every court in this country runs on the assumption that Justice Department prosecutors represent the United States, not any individual who occupies the executive branch. Grand juries indict on the assumption that the department's decisions reflect legitimate law enforcement judgment. Foreign counterparts cooperate with American federal agents on the assumption of institutional independence. Every single judge who reviews a DOJ filing assumes an obligation to the public interest, not to whoever holds the appointment power. Those assumptions are the operating architecture of federal law enforcement. Confirming him tells every court, every grand jury, and, every foreign counterpart exactly what the Justice Department they're dealing with has actually become. And the Senate writes that answer into the official record. All right, that's it for today, and I appreciate you taking the time to watch. If you liked the video, give it a like. Let me know what you think in the comments, and subscribe if you want to see more. Hit the bell too, so YouTube actually lets you know when I upload. Thanks again, and I'll catch you in the next one.